Namaste everybody, I'm Tanya Pandey and I welcome you to the first episode of LiveLaw's limited 5-episode series on the most important judgments of the Supreme Court delivered in 2021. In today's episode, I'll cover 20 judgments and the remaining in the upcoming episodes. So let's dive right into it. In the month of January 2021, the Supreme Court in Rajeev, Suri versus DDA and others upheld the central government's plan for construction of the Central Vista project and the government's proposal to construct a new parliament in Lutyens, Delhi by a 2:1 majority. The judgment was pronounced by a bench of Justices A.M. Khanvilkar, Dinesh Maheshwari and Sanjeev Khanna, with Justice Khanna dissenting from the majority view. A bench of Justices D.Y. Chandrachud, Indo Malhotra and Indira Banerjee, in a judgment dated 11th January 2021, delivered in NN Global Mercantile Private Limited versus Indo Unique Flame Limited, observed that non-payment of stamp duty on commercial contracts will not invalidate the arbitration agreement. The bench disagreed with two earlier judgments in SMST Estate Private Limited and Garware Wall Ropes Limited in this regard. In Garware Wall Ropes Limited, it had been observed that the arbitration clause would be non-existent in law and unenforceable till stamp duty is paid on the substantive contract. Disagreeing with this, the three judges bench referred the findings in paras 22 and 29 of the Garware Wall Ropes judgment to the Constitution bench. Taking note of one-sided and unreasonable clauses in the apartment buyers agreement, the Supreme Court in Ireo Grace Realtech Private Limited versus Abhishek Khanna held that the same constitutes an unfair trade practice under Section 2, Subsection 1, Clause R of the Consumer Protection Act. The judgment was delivered by a bench of Justices D.Y. Chandrachud, Indu Malhotra and Indira Banerjee, which observed that the developer cannot compel the apartment buyers to be bound by the one-sided contractual terms contained in the agreement. By way of the verdict, the top court disposed of an appeal filed by a developer against an order passed by National Consumer Disputes Redressal Commission, which had directed the developer to refund the amounts deposited by the apartment buyers on account of the inordinate delay in completing the construction and in obtaining the occupation certificate. In the case of Union of India versus Messrs. Tantia Constructions Limited, the Supreme Court referred to a larger bench the issue whether the appointment of an arbitrator by a person who is disqualified from being an arbitrator as per Section 12, Subsection 5 of the Arbitration Act is valid. In a 2019 judgment with Core and a joint venture company as parties, a division bench of Justices R. Bhanumati and A.S. Bopanna had held that appointments by an authority who is disqualified from being an arbitrator can be valid depending on the facts. However, the three-judge bench in this case doubted the correctness of this decision and referred the issue to a larger bench. The very same bench of Justices R.F. Nariman, Naveen Sinha and K.M. Joseph in Manish Kumar versus Union of India and Connected Matters also upheld the constitutional validity of Sections 3, 4 and 10 of the Insolvency and Bankruptcy Code Amendment Act 2020, in effect upholding the threshold limit on home buyers. Section 3 of the amendment has inserted certain additional conditions for home buyers to initiate insolvency proceedings against defaulting builders. The amendment to Section 4 had inserted an explanation to Section 11, and Section 10 had inserted Section 32 capital A in the IBC, whereby the liability of a corporate debtor would have ceased to exist on the date a resolution plan was approved and new management took over. The contention of the petitioners was that this would leave the individual creditor without remedies and that such conditions on home buyers amounted to hostile discrimination, violating Article 14 of the Constitution. The Supreme Court rejected these arguments. The Supreme Court observed that the benefit of probation under the Probation of Offenders Act 1958 is not excluded by the provisions of the mandatory minimum sentence prescribed for offences under the Indian Penal Code. In this case, the accused were convicted under Section 397 IPC and were sentenced to undergo rigorous imprisonment of 7 years each. The state contended that since IPC prescribed a minimum sentence of 7 years, it could not be reduced below that period. However, the court, relying on the 1973 judgment in Ishar Das versus State of Punjab, observed that Section 4 of the Probation of Offenders Act reflected the legislative intent that provisions of the Act would have effect notwithstanding any other law in force. The Supreme Court, by 4:1 majority, dismissed a batch of review petitions challenging the judgment of the Constitution Bench in the Aadhaar case. Justices A.M. Khanwilkar, Ashok Bhushan, S. Abdul Nazir and B.R. Gavai observed that no case for review of judgment dated 26 September 2018 was made out. Justice D.Y. Chandrachud, on the other hand, dissented. The review petitions assailed the reasoning in the opinion of the majority on whether the Aadhaar Act was a money bill under Article 110. The majority observed that change in the law or subsequent decision or judgment of a coordinate or larger bench by itself cannot be regarded as a ground for review. In context of the 2013 Supreme Court rules, the top court left it to the rule-making authorities to examine whether they would like to expand the registration of advocates on record to permit persons to carry on the profession in the style and name of a sole proprietorship firm. The bench of Justices Sanjay Kishan Kaul, Dinesh Maheshwari and Rishikesh Roy said, and I quote, "The Supreme Court rules being sacrosanct, we would not like to interfere with the same in the present proceeding," unquote. The Supreme Court held that Section 43D(5) of Unlawful Activities Prevention Act per se does not oust the ability of constitutional courts to grant bail on ground of violation of fundamental right to speedy trial. A bench of then Justice N.V. Ramana, Justice Surikant and Justice Anirudh Bose passed said order in an appeal filed by the National Investigation Agency against the Kerala High Court order granting bail to the accused in palm chopping of Todupura Newman College professor T.J. Joseph in the year 2011. A bench of Justices D.Y. Chandrachud, Indira Banerjee and Sanjeev Khanna observed that its decision in V. Surendra Mohan versus State of Tamil Nadu, reported in 2019 Volume 4 Supreme Court Cases at page 237, would not be a binding precedent after the coming into force of the Rights of Persons with Disabilities Act 2016. In the Surendra Mohan case, a two-judge bench of the Supreme Court had held that stipulating a limit of 50% disability in hearing impairment or visual impairment as a condition to be eligible for the post of judicial officer is a legitimate restriction. The Supreme Court dismissed the review petition filed against the Shaheen Bagh judgment, in which it was held that demonstrations expressing dissent have to be in designated places alone. Dismissing the review petition, Justices Sanjay Kishan Kaul, Anirudh Bose and Krishna Murari held that the constitutional scheme comes with a right to protest and express dissent, but with an obligation to have certain duties, and that the right to protest cannot be anytime and anywhere. The Supreme Court on 18th February closed the suo motu proceedings, which were instituted to examine if there was a larger conspiracy behind the allegations of sexual harassment against the then Chief Justice of India, Ranjan Gogoi. The bench of Justices Sanjay Kishan Kaul, A.S. Bopanna and V. Ramasubramanian observed that an inquiry panel headed by former Supreme Court Judge Justice A.K. Patnaik had submitted a report opining that a conspiracy behind the sexual harassment allegations could not be ruled out. The report also surmised that certain tough stances taken by ex-CJI Gogoi during his tenure could have triggered the allegations. However, the veracity of the allegations levelled by lawyer Utsav Singh Mehes could not be verified completely due to the limited access of records and other collaborative material. In this backdrop, the bench closed the suo motu case. Whether the day of remand is to be included or excluded for considering a claim for default bail, the Supreme Court has referred this issue to a larger bench. The court was considering the appeal filed against the Bombay High Court judgment, which had held that the day of remand has to be included for the purpose of computing the period of 90 days or 60 days as contemplated in Section 167, subsection 2, Clause A, subclause 2 of the Code of Criminal Procedure. The Supreme Court held that declaration of moratorium under Section 14 of the Insolvency and Bankruptcy Code covers criminal proceedings for dishonor of check under Section 138 of the Negotiable Instruments Act against the corporate debtor. A bench of Justices R.F. Nariman, Naveen Sinha and K.M. Joseph delivered the judgment on a batch of petitions which challenged the continuation of criminal trial under Section 138 NI Act during the pendency of liquidation proceedings in the National Company Law Tribunal. Settling an important issue in the income tax law, the Supreme Court on March 2, 2021 held that the amounts paid by Indian companies for the use of softwares developed by foreign companies do not amount to royalty and that such payments do not give rise to income which is taxable in India. Therefore, there is no liability for Indian companies to deduct tax at source with respect to purchase of software from foreign companies. The bench of Justices R.F. Nariman, Hemant Gupta and B.R. Gavai was hearing a batch of over 86 appeals which challenged the decisions of various high courts, holding that consideration paid for purchase of foreign software amounts to royalty. The period of limitation for filing the petition under Section 34 of the Arbitration and Conciliation Act would commence from the date on which the signed copy of the award was made available to the parties, the Supreme Court held. The bench of Justices Indu Malhotra and Ajay Rastogi observed that there can be no finality of the award except after it is signed. The Supreme Court read down Section 12, Subsection 2, Clause C of the Maharashtra Zilla Parishads and Panchayat Samitis Act 1961, which provided reservation of 27% of seats in the Zilla Parishads and Panchayat Samitis. Reservation in favor of OBCs in the concerned local bodies can be notified to the extent that it does not exceed aggregate 50% of the total seats reserved in favor of SCs, STs, OBCs taken together, the bench of Justices A.M. Khanvilkar, Indu Malhotra and Ajay Rastogi observed. A bench of Justices R.F. Nariman and B.R. Gavai held that a sole proprietorship will fall under international commercial arbitration if the proprietor is a habitual resident of a foreign country, notwithstanding the fact that the proprietary concern is carrying out business in India. The bench set aside an order of the Delhi High Court appointing an arbitrator in the case, holding that the High Court had no jurisdiction as the dispute was an international commercial arbitration within the meaning of Section 2(1)(f) of the Arbitration and Conciliation Act. In a significant verdict, the Supreme Court on 16th March 2021 held that consumer complaints filed before the coming into effect of the Consumer Protection Act 2019 should continue in the fora in which they were filed as per the pecuniary jurisdiction under the previous Consumer Protection Act of 1986. The material provisions of the Consumer Protection Act 2019 came into effect with the notification published on July 20, 2020. The new Act had repealed the 1986 Act. The Supreme Court ordered that all proceedings instituted before July 20, 2020 shall continue to be heard by the fora constituted under the 1986 Act, and they are not to be transferred to the new fora as per the pecuniary jurisdiction under the 2019 Act. The Supreme Court observed that the time period for investigation specified under Section 167 of the Code of Criminal Procedure cannot be extended by seeking to file supplementary charge sheet for offences under the Unlawful Activities Prevention Act. A bench of Justices Sanjay Kishan Kaul and R. Subhash Reddy, while granting default bail to Fakhre Alam, a person accused under Section 18 of the UAPA Act, referred to the judgment in Bikramjit Singh v. State of Punjab and reiterated that default bail under first proviso of Section 167, subsection 2 of the CRPC is a fundamental right and not merely a statutory right. This is all for today's episode. So far we've covered 20 judgments and we have a lot more to go. I'll be back with the next episode very soon, so stay tuned. Thank you for joining us today. I wish you a great week ahead.